What do you do when your employee files a labor case against you? And how can you protect yourself and your company from being jeopardized by your own staff? Welcome to the 8th episode of The Pivot. On this episode, we'll be focusing on the labor code, but we'll be focusing from the perspective of an employer. And of course, we've got our two lawyers here to answer all your questions about the labor code and startups and anything you need to understand. So stick with us on this episode of The Pivot. Hi everyone, you're watching The Pivot, your legal guide to startups, business innovation, and of course, the online world. I'm James Deacon.
And I'm Attorney Bernice Piñol. And this week we are joined again by my law partner, Attorney Henry, to help answer the questions sent in by our viewers. Attorney Henry, I'm glad you're back. How are you? How was your last experience with us?
Well,
good?
This is my second time, so baka natuwa kayo sa akin.
Oh, yes, of course. Yeah, so I'm glad you're
Thanks
here
for
to
having me.
answer
There's
the
no
questions.
obvious signs
with
of
us.
trauma, so I think we're pretty good. Attorney, we're focusing today on the labor code, but from the perspective
That's right.
of the employer. This is often not a perspective that is really taken into account, right? Because I think the labor code, am I right in saying that in some ways, is it fair to say it feels like it favors the employee?
It
Is it by
does.
design? Is that how it's supposed to be?
Yeah, that's why it's called the labor code. So,
Okay.
It's in favor of labor.
But how about, there's of course two sides to that coin, and the employer
Exactly.
needs to be protected as well. How can they protect, or do you have cases that you can bring up where you can protect the employer from an abusive employee that exploits the law?
yeah, there are a lot of cases decided by the Supreme Court on that.
And the Supreme Court also says that it has to be balanced. The rights of the employer vis-a-vis the rights of the employee, because the labor code is biased towards or partial towards the labor or the employee because they are really at a disadvantage. I mean, we are also employees, but we're also employers because employees have that disadvantage, right? That's why the labor code favors them. However, that should not be abused and that should not be, imbalanced. So today we're going to be talking about the rights of the employer because that's not often discussed. For some reason, the materials are quite scarce out there. If you look at YouTube, you look at the rights of an employer, what comes up is the rights of an employee. So for this episode, we're really gonna answer that because we want to support startups and business owners in these kinds of legal problems. So I believe we have a lot of questions.
We have a lot of questions, and we have a
Yes.
lot of examples too that we're going to be sharing with you. So if you can relate to these, hopefully we can answer your questions. Let's start with one here. I'm not sure if it has a name, but dear attorney, I'm a startup business owner in Makati and have 12 employees in my company. Last August, my marketing supervisor tendered her resignation citing personal concerns as the reason for her decision. A few months later, on November 16, I received a summons from the Office of the Department of Labor and Employment inviting me to a single entry approach regarding a complaint for constructive dismissal case filed against me by my former marketing supervisor. I don't understand why she would do this since she did tender her resignation to me and I never did dismiss her. My question is, what should I do in response to this comment or complaint filed against me? What is meant by constructive dismissal and what is my defense?
You wanna answer that?
Well, constructive dismissal is actually a resignation, a forced resignation as you call
Forced
it.
resignation.
It makes the employee resign or relinquish his post because of a situation where he cannot bear it.
Okay, so her personal decisions, what we're assuming is because she felt like she
Yeah.
was...
Well, the classic example is usually sexual harassment.
Sexual
or,
harassment
Yeah.
or maybe defamatory
Yeah.
words or like insults. But in this case, so the business owner is asking if why is it that she already tendered her resignation but she still filed for a dismissal case, illegal dismissal case. And so I think we have to clarify that that is possible, that even though the employee has already tendered a resignation, there can still be a case filed against the employer because there's what you call constructive dismissal, as explained by Attorney Henry, when the workplace or the work environment has become so unbearable that the employee is forced to resign. So for example, minumura mo araw-araw yung empleyado mo.
Yes.
Then, even though there's a resignation, that resignation was not voluntary. So it's now constructive dismissal. But here, I guess our advice for this startup business owner is to go through the SENA So the SENA kasi, or the single entry approach, that's the first step.
What single entry approach?
Yeah,
It's
it's
the
supposed to
level.
be a mediation part of the
Mediation.
Okay.
case. So before kasi there's no SENA. So they go through the labor arbiter and then the labor arbiter will say, oh, mag-aayos ba kayo o magkano ba gusto mo? So to avoid that, they go through the SENA
Later,
first.
okay.
So para ma-prevent din yung clogging ng cases sa labor
So
arbiter.
parang DTI mediation, but
Yeah.
for
So
labor.
kung dito pa lang sa SENA, maayos na.
Okay,
Then
so
everything is okay.
just want to make it clear from this point that we're not judging this case. We're just
Yeah.
showing the possibilities of what could be his liability here. We're not
Yes.
saying that this employer actually created an untenable atmosphere for the employee. But this is the example you were trying to use, that you could
Yes.
force an employee to quit by making it an unbearable situation,
Yes.
and this is the possible outcome.
Yes.
So does this employee now have to bring in proof that
Definitely.
she was either sexually harassed, or she has to give evidence that this was created to make her
For sure.
force
Yes,
a resignation?
Yes. So after the SENA, if there's no settlement that can be had in that time, that conference, and they're trying to settle, and there's no settlement reached, what happens is that this will now be submitted for filing of position papers. So the employer, let's say I'm the employer, I'll file a position paper and the employee will file a position paper. So that's where you put all the arguments. Right, so I've been a lawyer for both sides, and so usually, since what the person asking is an employer, so what you do is to definitely, number one, hire a lawyer to draft that position paper for you, because you can't DIY that. You have to be, it's very legal, diba? So in that position paper, you lay down all of your arguments. So you explain to the DOLE, to the NLRC, why there was no constructive dismissal. So again, you go back to the elements, like, was there difficulty, did you make it difficult for that employee to go to work or whatever. So you base you present all of your facts, and to show that there was none, and that the resignation was voluntary to begin with. So you have to argue it that way. So the way to defend yourself if an employee sues you for constructive dismissal is to show that there was no circumstance or no situation that was made in the workplace to force that person to resign. So you can have affidavits of witnesses. You can have text exchanges between this employee to show that she was okay naman pala, he or she was okay naman pala. So you have all these evidence, right?
Yeah, just to be fair to this particular question, it can happen both ways. You could be
Yes.
the employer, could be the one either
Yes.
sexually harassing, or it could be the employee saying, there's a loophole here
Exactly.
that I can
Exactly.
say that I was put in this position.
Exactly.
Okay, I think we made that question clear. We have a few more, so let's go through some of them here. Question number 2. Dear attorney, I'm the general manager of a grocery store, and I have an employee who constantly violates company rules, like coming to work. I guess that's late.
Late every day.
Late every day. Okay. Do you have the rest of the question
Oh,
there?
I'm sorry. Okay, sige, I'll read it for you, Tito James. So, coming to work late every day and smoking within company
Wow,
premises.
okay.
So, he keeps repeating the infraction even though we have warned him several times not to do this. His actions have greatly affected our operations, and I believe it's best if he is removed. Can I just fire him right away?
Very good question, because I have a follow-up for this. So let's first start with your answers.
Well, the termination should be on two folds. One is the procedural aspect, and the other one is the substantial aspect. Many employers are usually not aware of this. You have to follow the procedural aspect. You just can't terminate anyone just because you want him to be terminated. You don't want to see him tomorrow.
Yeah.
So you have to follow the 2-notice rule. That's the procedural aspect.
Yes.
Next is the substantial. It answers the question, did he really commit the offense? The procedural aspect is the 2-notice rule. Is you follow the 2-notice rule. And then that you give the employee one notice to explain. The next notice will be his termination or his
The
decision, or whether you terminate him or not. The substantial is whether he or she has committed the offense. So if you follow both, then there's no illegal dismissal.
Well, if the substantial one, you can fire on the spot.
Yeah, what I'm trying to say is, even though he's guilty, but you didn't follow the notice rule,
Yes.
you'll be liable for illegal dismissal.
That was my follow-up question, because in somebody very close to me had that situation, and that employee was actually caught stealing.
Yeah.
And he couldn't understand because it's like it's stealing already, but then he didn't follow that procedure, and that person won the labor case even though may CCTV na naka.
Probably the two notice rule was not followed.
Yes,
Yeah.
so it's very important to warn
The
people
two
of
notice
this.
rule isn't really like absolute. Okay, you're already parang you already failed, right? It's just a basis that you were not able to follow or parang to prove the substantial ground for your dismissal. So if you didn't follow the two notice rule, you'll be penalized with just like a 30,000 peso sanction. But also the disadvantage of that is that you were not able to prove that there was in fact a substantial reason for the dismissal. So that's why it's very important to follow the two notice rule. And so for this case, this grocery general manager, ang question niya was, can I just fire him right
Because
away?
it's like insubordination, right?
Yes, no, you cannot fire the person right away. It's very different with like movies, like you're fired or
Yeah.
what
Yeah,
is that
it's,
show of
Donald Trump, yeah, The Apprentice.
The Apprentice, right?
You're fired.
Oh.
Well, it doesn't work that
Don't
way.
we all want to like
No.
say that na lang, no? But no, you can't do that under the labor code because the U.S. Jurisdiction or the laws of the U.S. is very different. I think it's what you call at-will employment sa kanila. So they already have an agreement na parang I can just fire you right
Oh,
away.
okay. So
Yes.
there's all right.
Yeah, it's different. Their labor laws are different. So it's called an at-will employment. Dito, hindi ganon. So you really have to follow the two notice rules. It's very difficult.
And if you don't follow the two notice rule, it'll be
You're screwed.
you're screwed, and you'll be liable for damages.
Yes,
Although
yes.
the termination will be justified.
It can be, but it's
Oo.
difficult.
But
so you have
the Supreme Court or the labor arbiter will say, well, there's already a substantial evidence to prove that the employee really committed the offense. But the employer did not follow the two notice rule or the procedural aspect. Then he will be just liable for a fine, the damages of how much, 30,000
So
or
just to
something.
contextualize with this one, sige, Mr. General Manager, let's call you that, Mr. GM. What you do is first you talk to your HR and then you check the policies. Saan ba nakalagay yung policy na bawal smoking,
Yeah.
bawal tardiness? Of course, no, it should be bawal, right? So you put that in the first notice or the notice to explain. You write that down like, Dear Employee X, in this date, you committed these offenses and it's in violation of this. And then you say that these violations could be a ground for your suspension or termination. So you really have to give due process and to follow due process into that, in that you are making the employee aware of what he or she did and the consequences for that act, diba? So that's the first notice. And then what happens usually is that they will reply with an explanation, like a reply, written reply. And then after that, pwede din admin hearing.
Yeah,
like
and
you call them.
the employee can hire a lawyer
Yes,
if he
yes.
really
A
wants.
lawyer could actually,
You could
even
be
though
assisted.
it's not really the court, no? But yeah, you can be assisted by a lawyer. So there's an admin hearing now. I've attended so many of these. It's very painful as a lawyer for the company because you see the employee and you argue, things like that. But yes, that step is very important also to extract more evidence if you're the general manager. And then if all the evidence would lead to prove that the employee really is tardy, he really is smoking within the premises, then you can issue now your decision, which lays down your grounds and your reasons, diba? So you can also prove na smoking is such a serious offense because it's a grocery, diba? What if may sumabog? So mga things like that.
Yeah.
That's usually overlooked by the HR. I'm sorry to say this. It's very common. So you have to be careful. As a GM, you have to work closely with the HR and make sure that the law is followed in this way.
Speaking of HR,
May hugot ka
at
sa
what
HR.
point at what point can you justify HR? 10 employees, 5 employees, 20 employees? I mean, I know it's an arbitrary question, but in your personal opinion, when does an HR start to pay itself off?
What do you think?
What do you think? More than 5 or to 10?
More than 5.
Yeah.
Because like you think this is an area where you could make tipid, diba? If
Yes.
you're starting
Yeah.
a startup. Like,
You can be the HR if you want.
yes,
Yes.
but then at what point, like we're talking about, if you're not following procedures and
Yes,
stuff,
yes.
do you really want that headache? Because that headache could cost you quite a pretty penny later on.
That's
You could be
right.
up for even up to $1 million
Or-
or something.
Hire a lawyer for
Yes,
retainer.
yes,
Then
yeah.
For a retainer,
The
you can-
lawyer could actually stand as an HR.
Okay, just to
sometimes.
make sure that all of these
Yeah,
Yes,
you're
follow.
free to. You're not actually free.
Consult.
You can free to consult, and you can always ask the lawyer, your retainer, to yeah, but I have this issue with my employee. What can I do?
Yes, yes.
Okay,
if you're
well-
a startup, you try to be lean as
Yes,
possible,
exactly.
right? So you wear a lot of hats. So yeah, you can be HR, but also you also have to have a retainer lawyer or like consult with a lawyer just to make sure that the labor law is being followed.
But after 5, you think it tends to make sense. No?
Oh, yes,
It
yes.
tends to
Yes,
justify
yes.
its own position, its
Uh-huh.
own
For
expense.
sure, for sure.
Okay, another question I have is we talk a lot about unfair dismissal and all that. That's usually, I guess, the bulk of cases in labor. Can an employer make, let's say, how far can they go with somebody's personal Facebook account, right? It's like,
Oh.
can you don't post this, don't post that. I didn't like what you posted.
Yeah.
You know, I mean, there's a gray area there because you're thinking, that's my personal account, but yes, you represent my company too. So
That's a good question.
where do you?
Well,
what are we
yeah.
allowed to do?
Well, if the post is, will endanger the business, and or
Correct.
derogatory to the business, then you can discipline him.
What if it has nothing to do with the let's say the business? Okay, now
Like
we're in
the
election
employee.
season,
Okay.
diba? So we're your employee is campaigning
Yeah.
for a you know,
Candidate, yeah.
not officially, but you know, being that noisy person, and it's attracting all this hate because
Yeah.
you know politics is very divisive, and you as a boss, like, listen, I don't want my manager, my staff.
No, marami niyan.
Yeah,
Maraming
but
ganyan.
can you? I mean, is that like they'll say, look, that's my freedom of expression. That's my right to vote. That's my right to campaign. It says yes, but you're bringing in all this negative energy into my company. But it's a gray area because you are encroaching as well.
You know, the right to vote is very personal to the employee.
Yeah.
But what about the right to, you know, be very vocal? That's attracting all
It's
this
okay.
negative
I
energy.
mean, as long as you don't post against the company.
Yeah, I guess they have the right to post because you know it's your right to have a voice in politics and everything. But if, for example, you have a contractual agreement with your employer that it's stated there clearly in the contract when you entered that company that you're not supposed to give any
So you
political.
can.
You have to be non-partisan.
All right.
let's
Well,
say.
that answers
Yes,
that.
it has to be covered by a contract, but generally, no, you cannot control your employee with everything.
But that's
that
well
they post.
within.
Yes,
If you do that in advance, because like in, let's say, my industry, it's not necessarily employer-employee relationship. It's client and relationship.
Yes.
And my clients will definitely say, listen, if we're going to engage with you, especially for endorsements, you got to stay clear of politics for obvious reasons. And
Yeah.
I'm happy for that because I don't want to be
It's
in
not your
that.
personality
It's not my
anyway.
personality. But if I can understand that, but that's a different relationship. That's a client relationship and contracts, endorsements,
That's
etc.
right.
You're saying that you could make this imposition on
could.
employee in advance.
Yes, you could, as long as it's agreed
Yes.
upon, as long as there's consent. But if there's none, then it's hard to control your
It's a lie.
employees.
It's so
But for
hard
example,
to.
then, like for example, if your employee posts like a two-piece, ganyan, and you want to reprimand that person, I think it's a case-to-case basis, diba?
Yeah, let's say
Depending on the
let's say
industry.
you're a teacher
Exactly. That,
and you
that
you
would be
post a
it.
two-piece on your Instagram.
Yun, pwede ka, you can be sanctioned. Like, teach, what's up?
Yeah.
It really depends on the nature of the employee.
Exactly, exactly.
Did you remember there's one, I don't know if there's one TikTok
What's that?
post with the teacher dancing.
Oh, I
Yes,
didn't
yes,
know
yes.
about this.
That
but
became
this-
viral and he
Yes,
was
because
he
his
was
caption
really
was
disciplined.
like, his caption was,
His caption, when
nagpapakute.
QT estudyante is
That's so- that's
approaching,
kinda gross.
pakit-pakit
Ay,
muna.
well, okay. Yeah.
So
It's
he
kinda
was,
gross.
his post was really
Very
viral
inappropriate,
and maraming
yes,
nagalit
yes.
doon.
As
Even
an employee, you can be sanctioned that way.
Oo,
right?
because you're a
your
teacher.
industry is academe, diba? If your business, however, is like a beach resort, then you're okay to be you have to be appropriate.
Okay, so let's
Yeah.
get some key takeaways here because I think it's very important to condense this down. There are situations where you can make impositions with your employees regarding even their personal accounts, but you have to do that in advance, and it's got to be consensual, and it's also got to be relative to the industry. I mean, like you said, if it's a beach resort, well, yes, okay, fine. But if
Yeah.
you're teaching primary school, kindergarten, and stuff like
it's
that,
so inappropriate.
yes, there, and even if it's outside of your work
If
hours,
you're a lawyer,
if you're a lawyer, well,
can you post your two-piece?
I think
Because
I think you should increase engagement.
I haven't gotten in trouble because of that. But yeah, context is very important. Context is very important. So we have another question. Shall I read it
Yes,
for
please.
you guys? Okay, so question, Dear Attorney Bernice, I have a startup business and in the past year, our profits in the company have been doing well, even though our business is still relatively small. And I only have 5 employees. But in the last week, I have been getting reports from my staff that my trusted treasurer, who also acts as my cashier, have pocketed from my company's income by not declaring some payments made by other clients. What are my rights as a business owner in light of this? What can I do to protect my company from possible theft? What do you think?
Well, preparing for, well, I assume that the
There are some facts missing, no? But
yeah,
based
but I
on-
assume that the employer is really want to terminate her na.
yes,
So
I think yes.
first thing you know, since
Or how to protect just the rights of the
well,
company.
it's actually accounting and audit. It's usually like that. So especially with labor, you have to be precise when it comes to numbers. Because any doubt when it comes to labor, it really resolved in favor of the employee. So you have to be certain
Yes.
that you have this and then somebody steals this much. Diba? So
Yes.
you have to prove that. The burden of proof is in the employer.
Is
pa
on
rin.
you,
So
yes.
you have to be precise in everything. You have to make an audit, make an accounting,
That's
and
right.
then
Because those are all evidence, pieces of evidence that you can use. Because what you can do here to protect your rights is, number 1, you can terminate the employee, and number 2, you can file for a case of qualified theft. Because qualified theft is when there's already confidence and trust, and that person breached that confidence and trust and, stole from you. So it's not just regular theft, it's much heavier actually. And so, but for you to do that, you have to have proof. There has to be, like what Attorney Henry said, accounting. You have to have witnesses, you have to have evidence to prove that there was in fact theft or qualified theft that happened.
qualified theft is actually the most common crimes that is filed against
For
employees
employees.
because it involves bank tellers,
Yes.
cashiers,
So
collectors.
You're in a position of trust that
Exactly.
you have, yeah.
Exactly.
That's the common crime that is being filed against employees.
Is there a statute of limitations on this? I mean,
Well,
There
I think-
is prescription. I'm just not sure how many years.
But it depends on
On
the
the penalty.
penalty. But it's not, pero alam ko pag qualified theft, mabilis lang yan. So you have to file it
File
agad.
immediately.
You make the audit agad, make the findings, and then file it agad.
Yes. And the problem with delaying the filing of cases is that you could lose the witnesses.
Yeah.
You could lose the evidence.
Practically, yeah.
So our advice for this startup business owner is to, take action immediately and to make that accounting and to collect all the evidence you have and to protect your business. Kasi nga, pilferage could happen and stealing could happen and there could be abuse if you just, turn a blind eye on all these things and not do something about it. So protect your business in this way. Make sure that the process is correct. Don't just be like, you're fired based on,
Yeah, TV
like
show.
chismes
Yeah.
or whatever.
Plus, you can always suspend the employee for 30 days
That's
because of
right.
the nature of the job. The
Yes,
employer has that
preventive
right.
suspension.
Yeah, but because of the nature of the job, you could be suspended for 30 days without
Yes.
pay. You can do that. You
Yes,
can do that.
yes.
And
And follow the 2 notice rule. pa
yeah,
rin.
yeah. So you just said in the letter that in the notice explained, by the way, because of the nature of your job,
Yes.
you would be suspended for 30 days
And
in
the
order to
purpose-
prevent
there
further
you go.
damage. Yeah.
There you go.
Okay, so we've covered quite a few of the common cases: the qualified theft, the unfair dismissal, the what was it with the sexual force,
Constructive dismissal.
constructive dismissal, very very relevant cases and all that. But what is there any advice you can give employers to preempt this or to preventative stuff? Can they have like documents that they should standardize for every employee? Do you have any advice for people starting up who want to protect themselves from?
You make everything on paper.
That's right.
Yeah, you
Have
get
an
although
employee
although
contract.
the labor code is your contract with the employee. You can have a separate contract with the
Yes.
employee. Make them sign the policies and work ethics rules. Yeah.
Code
So
of
there's always
conduct.
this is
Yeah,
something
code of
you would
conduct.
advise everybody to
Oh,
do,
yeah.
who's
Oh,
no
yeah.
matter how big or
I think
small.
everybody's
company.
using that
Okay.
Kasi para lang malinaw ang lahat.
Yes.
And that's as simple as writing it down as an how does
As a
that work?
contract.
As a
As a
contract,
contract.
you get notarized.
Yes.
It has to be notarized, signed.
yes.
You keep a copy. They keep a copy.
Yeah.
All right.
It's put in your 201 file. So the documents have to be in place.
All right. What about the rights of an employer? Because we talked about the 2 notice rule and all that. That's for the employee. What are some of the rights of the employer that they should know?
So aside from the grounds for, the termination that we've discussed and have, be able to protect your business by filing cases of termination, let's say, or criminal cases. The employers also have the right to, make management decisions and, kind of like dictate like the place and time of work and how it should be done.
Yeah,
the
the
transfer,
transfer.
yeah. So there's what you call management prerogative. So that's what the employers can hold on to, that the decision making of the company lies on them. So the employees cannot question that one. And also the employers can also have the employees terminated. And even if it's I think it's better to have like a probationary contract with an employee, because for example, a new employee is not at par with the quality or the quality of
Standards.
work and the standards that you have. You can remove them without the two notice rule, just a notification that you did not meet the there has to be notice pa rin, no? But it doesn't have to be so rigid. You just have to say that you were not able to meet the standards, etc., like that. So yes, you can maintain your quality and your standards in the company, but make sure you follow the rules under the labor code.
All right. And is there like any third party where you can get sort of like advice from? I mean, you said get a lawyer and retainer. What if you're not big enough yet? How do you sort of make sure that you're ticking all those boxes, crossing every T, dotting every I's? I mean, is there a cost-effective way when you're just starting, or does it really hire a retainer, a lawyer?
You can just call Attorney Henry.
Well-
So you can have consultations with us maybe, so it's not really like a full-on retainer, right? So consultation is very important. So just to get you through the basics, and don't wait until like a labor case is filed
Yes.
against you, for
Which
sure.
usually happens.
That's what we're
Yes.
trying to avoid here. I
Yes.
guess that's the problem we're trying to solve. It's like, you get so excited when you're starting a new
Yeah,
business,
yeah.
especially something in this climate, a startup, and you're like,
Yes.
we'll deal with all that later.
Later,
Yeah,
yes.
what's important is the market and the
Yes.
product and the this, and it is. It's very important, but it's very easy to sweep these things under the
Exactly.
rug. And like you said,
Exactly.
Attorney Henry, don't wait
Yes.
for it to be in a labor court
And
case.
especially with a startup, with the nature of a startup business where everything is so fast, right? It's not like any traditional business. And so you want to kind of like get rid of a bad employee as soon as possible.
Yeah.
So you still have to follow the rules, right? You can do that naman like fast, but make sure you have the two notice rule pa rin.
And also understand that the problems are never there when there's no money, right?
Yeah.
Yeah.
The problems start to come about when the company starts
big
doing
now.
well. Yeah. So it's very easy to just ignore all of these in the beginning because you're like, oh no, we all get along, and look, we'll never get money or in the way of our friendship or the employee relationship. No, it's about you want to start off, even if it's boring. If you don't want to do it, you can always have
Outsource.
outsource it. But don't ignore it,
Yeah.
because
That's right.
later on that
That's
will
right.
fester and grow, and it could become a very big problem, and it will be the thief of joy of your business.
That's right.
It's
Well
like
said, Tito James.
it's actually like making the doctor cure you of cancer. Di ba?
Yeah, and you're doing all the unhealthy things.
Yeah, then
along the
sasabihin mo
way.
I always say this to my client, pumunta ka sa akin, cancer na yung sakit mo. Paano ko pagagamutin yan? Diba?
Yeah.
Yeah.
But you still can, di ba?
Yeah, but you
course.
can damage control na yun.
That's
Yeah,
That's
don't
really-
wait. Yeah, with stage ones, there's even cancer has
Yeah.
stages. No, stage 1, stage 2, stage
That's
3.
really hard for the lawyer to do it. Kasi
And it's more expensive
damage
na.
control is really hard. And because it's hard, we charge more.
What are some of the, before we wrap up and leave, I mean, what are some of the standout cases that you think are worthy of sharing here? Like either crazy situations or anything off the top of your head that you've handled?
Yeah, with labor cases, I've handled a lot of labor cases, and I've tried having like a kind of like an implied or like a very subtle death threat. In that after the Senate hearing, some of the employees actually took photos of me just to kind of like intimidate me. So that's
Wow,
very
that
risky.
was on a personal level. They were,
Yeah, it's a very
Yes,
risky
because
job we have.
I know
Because they're
it's
so angry with the
Yes.
company that it transfers on you. I mean, you are looked at as a representative of the company. So
I would think it would be sort of the same dynamic as like a domestic violence and how when the police are get involved,
Yes.
it's just so highly explosive and highly charged.
Yes.
And with an employee, that's your livelihood.
Yes,
So I
exactly.
mean, especially if they feel that they've been hard
Very,
done
very
by,
risky.
and the lawyer is standing on the other side
But
protecting
we're
their
good.
company.
We're okay. We're okay.
Okay, all right. Let's wrap it up there. But let's do a little recap so that because there's been a lot of valuable information here. How would you like to recap here? I remember the 2 notice rule, very important. Getting your contracts done in advance. Trying to at least think of having an HR or somebody assigned to that position, even if it's a dual position. After about 5 employees, it should start paying itself off. What else did you want to add?
Well, if you see that there's somebody stealing, act right away. First to know, first to act, right?
That's right.
So make the accounting first, make the audit, get the findings, and then file a case.
All right. Okay,
Gotcha.
well, with all that, I think we've got this pretty much covered. But this episode, of course, wouldn't be possible just with the three of us. It takes a village to put this together. Attorney, who do we want to thank?
We'd like to thank Mama Lou's Italian Kitchen, David, Crystal, and Chef Carlos for always giving us
Perfect pasta.
delicious lunch every time. It's the thing we look forward to. And of course, we'd like to thank Home Lab for keeping us safe and making sure that everyone is swabbed and health protocols are followed. And this show is brought to you by the law firm of Piñol, Santos and Associates and the Aklan Group of Companies. So thank you very much for all those who week after week watch this show, and I hope you guys are learning a thing or two from us.
Yeah, absolutely. And if you're liking the content, don't forget to hit the like button and subscribe as well so that we can sort of get into that algorithm so we can help more people. Remember, it's all about helping people who are starting up in this new climate. At least that's where we want to put our focus on. There's so much to learn. There's so much to talk about. And we want to be here week after week giving it to you in the best form possible. So, pop your comments down below. If you have a question, you can always get a hold of us. We'd like to feature your question in one of our episodes. But till then, I'm going to leave it there. I'm James Deacon.
And I'm attorney Bernice Piñol, and we will see you. Oh,
Don't forget
thank you,
our
Attorney
special
Henry.
guest.
And this
Thanks
is Attorney
for having
Henry.
me. Yeah.
You will be back.
Of course. Yeah.
Yes. He's more of a regular now. And see you guys in 7 days. Thank you. Bye-bye.
Bye.